Tan, what do you hope to achieve by having this protest?
This is not a protest. It's an opportunity for the investors of the mini bonds, the high notes, to get together and meet other investors. And I hope that after that they will be able to get together to see their members of parliament or even to discuss, maybe appoint a lawyer or how to complain to the bank or finance company that sold them this product. So the investors should get together and discuss with each other.
So you think this should be done using a collective process?
Yes, because each person doesn't really know what to do. So by talking to other people, they get some understanding about what the problem is, and then they can get a better idea how to approach it. But I hope that the government will act on the petition. The petition has got 983 people. Ask the government to look into whether there were any wrongdoing by the financial institutions that marketed the product. And if there were wrongdoing, the government can, we hope, help the investor to recover some compensation, like what is being done in Hong Kong. Hong Kong Monetary Authority is quite active, so we hope that the Singapore Monetary Authority will also be active.
But they are saying that they are working with certain counterparties within 2 weeks and so forth. I think, how do you think we can resolve other than that? They have to wait for 2 weeks.
Well, I think the MAS hope can be more on the ball and look after what the problem is. So I think the investors like to have more positive action.
You're talking about appointing lawyers and so forth. Are you considering some kind of collective legal action?
Well, this is for the investors to decide. So many of them are getting together already and let them decide. I can only help them to find some law. Many of the investors, they were told certain things verbally by the financial institution that sold the product to them, and the verbal things they were told are quite different from what the product actually is. But of course, this is verbal, so they could not have any proof. But therefore, I arranged for them to see the lawyer, make a statement under oath. Oath means they must swear, honestly, this is what I hear. And if many investors say, I was told like that, other people say that I was told like that. If many people can swear that they are told like that, then I hope that the financial institution will say, will understand that their staff has told the wrong thing. If you have made a mistake, told the wrong thing, you must be fair to come and help to offer some compensation. You cannot expect the investor who are told the wrong things to bear all the responsibility. So I hope that the financial institutions will recognize that mistakes have been made, that they should take some share of it. I think we are all reasonable people. If someone is uneducated and told to sign all these disclaimers, is it fair? Do you have a duty when you explain to people, to tell people the truth? If you make a mistake, should the old folks be asked to bear all the loss? Now some people are old folks and they don't understand. All they want is a fixed deposit. And here you tell them, oh, this is like a fixed deposit. But it's very risky. So I think it's not fair. And I think the financial institution should come and say, yes, if we make a mistake, we must bear part of the loss. It's not fair because I also know many of the other investors, they are not well educated. They don't understand what they bought. Of course, if they don't understand, they shouldn't buy. But then the bank shouldn't be selling to them. Because many people will say, oh, we are told it's like fixed deposit.
Question, under Singapore's Financial Advisory Act, I think there is an the responsibility is on the banks and their representatives to ensure that the right and appropriate products are sold to customers, i.e. the risk profile must be correct, and also there's a certain amount of diversification. Is this on its own? Has this ever been used in court to challenge, say, to allege mis-selling, to the best of your knowledge?
I think there are some cases in other countries where this has been cases have been tried in court. To the best of my knowledge, I'm not sure about Singapore, but I hope that this is very clear under Section 27 of the Financial Advisors Act that the representative has to do certain things to check the risk profile, to make sure the product is suitable when they recommend to the investor. And of course, it's for the financial institutions to see if 1,000, 5,000, 10,000 people are involved. It's not just one or two, 5,000, 10,000 people are involved. They should check. And MAS must also check whether or not these people have told the wrong thing. It cannot be so many people who don't understand the product. They just buy it willingly.
Is it possible to share with us, out of your 983 practitioners, what are their profiles like?
I'm quite surprised that many of them are elderly.
What is the percentage?
I would think that maybe 20% or so. I don't have the exact number. And the amount invested is very big. $100,000, $200,000, $300,000. And these are people coming from quite modest occupation. They are not rich people. So this money represents, for many of them, a whole lifetime.
Do you think this calls for more regulation on financial
Certainly. I think these kind of products should not be allowed to be sold. And in Hong Kong, I think they realize, from what I read in the newspaper, the Hong Kong Monetary Authority will be actively considering to stop this kind of product being sold. But it's not just this. I think it's important that when products are sold to the general public, that somebody must check that these are okay. You cannot expect the general public to be able to check themselves. So that the duty to make sure that these products are suitable must be done by more expert people. Take for example, medicine. Can you produce a medicine and just tell the public you can decide for yourself whether to use? Because the medicine can be a poison, can kill people. Therefore, the government says before you sell a medicine, somebody will check and approve. The same should be applied to financial products. That you should not just allow any financial product to be sold. It has to be, somebody must check that it is suitable.
Is it the product that is wrong or is it the process of selling to the wrong people that is the problem?
In this case, both. The products should never be sold because these products, if you study it, is very dangerous. If any company go bust, you lose all of your savings. It's very dangerous. Normally, when you invest in the fund, you invest in many diversified entity. So if 5% go bankrupt, you still got 95%. But this is, if any one of the 6 go bankrupt, you lose all your savings. This is very dangerous. How can this kind of product be sold? And of course, who is responsible for approving this to be sold? And the financial institution that sell this product, do they know that they are selling this kind of product? Are they responsible?
Mr. Tan, do you think that the investors should also take part of the blame on themselves for not fully understanding the product?
Yes, I think many of them recognize they have to take part of the blame. After all, they are earning a higher interest, but they should not shoulder the entire loss. So many of them are quite realistic. If you offer them 50%, 70%, they'll be quite happy.